Hi everyone,
Welcome to the second episode of The Brief.
I'm Dheeraj.
I'm Sanam Siddiqui.
What's our brief today, Sanam?
This episode briefs you on what is force majeure,
When can it be invoked?
who can or who should invoke it,
Can force majeure be invoked due to financial difficulties?
what steps should one take to invoke force majeure,
Is it important for the force majeure event to be specifically mentioned in the contract?
what if there is no force majeure clause in the contract,
What if the force majeure clause in the contract doesn't specifically mention the event?
or what is frustration of contract. We're going to do a small question and answer round where we can help you understand force majeure better. Dheeraj, do you have any questions for me?
Yeah, Sanam, in case of a lease, who should invoke and why?
In case of a lease, it's the lessee that has to invoke. However, there is something very interesting here. Lease agreements are executed contracts. The prime purpose of a lease agreement is handing over of property, besides other additional services. So once the landlord has handed over the property to the lessee, his work is done, and therefore, even if there are force majeure clauses in those rent agreements, most of them will state that rent has to be paid even if you invoke force majeure. Dheeraj, what about the license? Who has to invoke it in a license agreement?
As against the lease agreement, it's the licensor who has to invoke it. In case of an immovable property, take for example the shared working spaces, wherein there are many entrepreneurs and business entities on the same floor. They're carrying out their own respective events and their own respective purposes under the same roof. However, it's a license agreement because they all come there with the permission of the owner. They're all sharing the space, they're all sharing the conference room. There is no proprietary interest, in the sense, no interest in the property itself is created. It is only in the services that are being provided. So, for the time being, in case, for example, if we take the recent situation, in case of the COVID-19, the government prohibited the licensor, that is the shared working space, from opening its doors. Analogy can be drawn in case of a hotel, which is prohibited from carrying out its functions by the government. If I'm not staying there, if I'm not using the services, then I cannot be made to pay for those services which I could not avail, which the government was prohibited from providing it to me. So therefore, it is the licensor who has to invoke it and not the licensee. What about in an EPC contract?
In an EPC contract, it's the contractor. Now, why is that? It's because in an EPC contract, the contractor is supposed to build or make or construct something. Now, let's say because of this COVID situation, because of the lockdown, there is no movement of labor possible. My labor comes from across the border. Therefore, I am not in any position to fulfill my contractual obligation of constructing the building or whatever it is. Therefore, it's a contractor that has to invoke force majeure. What about in a mall? Are they leases or licenses, first of all?
Now, mall is a very specific situation. The mall has leases as well as licenses. There are shops. The shops are on leases. However, at the same time, you have kiosks and those little shops in the middle, and you have display boards. What are those? Those are licenses. Those are not leases because they're only there because the mall owner has permitted them to use it. So, Sanam, what about in a construction contract?
In a construction contract, again, it's the contractor or the party constructing that has to invoke force majeure. And why is that? Again, it's because my part of the obligation is hindered. Therefore, I need to make sure I tell my principal as soon as possible that my working or my construction is hindered because of force majeure events, whatever they may be. So now we've understood about whether malls have leases or licenses. So who has to invoke the force majeure clause there?
In case in case of a lease in a mall shop, it will be the leasing who has to invoke the force majeure clause. However, We can never say whether the lessor will allow suspension or absolute preclusion of the rent for that point of time. But in case of a licensee, the licensee is not cannot be made to pay rather. Now take for another example, an individual store where I allow someone to keep their products for the time being and they pay me a certain fee for giving them that space in my shop. Are they lessees to me? No, they're not. They're only licensees to me because I have permitted them from you for using that particular space for that particular purpose, which is under my control, which is under my possession. So therefore, I cannot expect them to pay me for the time the contract cannot be performed. In a traditional lease for a commercial property.
Now that's actually interesting because in a traditional lease for a commercial property, it's an executed contract. All rent agreements are executed contract. Person who gave me the place on a lease, he has done his job. He was supposed to hand over the property or give me possession of the property. Therefore, his job is done. It was my job to continue paying the rent. However, last financial inability doesn't come under a force majeure event. So it doesn't matter whether I can't pay my rent because that will not fall under force majeure no matter what.
In case of an import of goods?
In case of import of goods, it's the exporter who has to invoke the force majeure clause because he has to say that he could not perform his obligation under the contract, that is to deliver the goods to me. What about if you're an exporter? Who then invokes force majeure?
Now that is an interesting situation because now there are many contracts of export, but we'll take a simple situation where I have to deliver the goods and the freight forwarder is also mine. So I only have to invoke it to say that for the time being the government has prohibited me from moving the goods from my factory to any of the ports or any of the airports. Therefore, it is the exporter who has to invoke it.
What about if the freight forwarder has been assigned by the buyer and is not yours?
Now that brings us to an interesting question. But I'll push that example a little forward to say the quality check has already taken place. Now it is a sale by description. And once the quality check is done, the description of the goods is done and the goods have been kept aside for that particular delivery. Now what will happen is, it is not me who's not able to deliver because my job was to prepare it, keep it in the godown for the buyer to have it picked up from my godown. So once the goods have, as per description, the goods have been produced, the goods have been manufactured, and I have kept them in a corner for them, for the buyer to pick it up, quality check is done. It is the obligation of the buyer to invoke the force majeure. It is not the exporter who has to invoke it like in the previous example.
So what is force majeure?
It's a contractual provision that discharges the parties from performing their contractual obligation. It describes uncontrollable events which makes performance impossible, inadvisable, commercially impractical, or illegal. So what is interesting is it is a contractual provision and not the law itself that we are looking at. Then what are the force majeure events?
Traditionally, back in the day, it was only natural calamities and disasters that qualified under force majeure events. For example, earthquakes, floods, avalanches, and other natural disasters. Nowadays, man-made events also qualify for force majeure events such as war, riots, change in government policies. So when can force majeure be invoked?
For it to be invoked, all these conditions have to be fulfilled. The event should be unforeseeable. It should be beyond the control of the parties. It should have arisen either during the performance of the obligation or prior to the committed date of performance. Affected parties should have taken all possible steps to mitigate the loss or to avoid the force majeure event. Now, who is an affected party? Party who is prohibited from performing its obligation. Take, for example, tomorrow there is a cricket match at a certain stadium. And today, the stadium gets hit by lightning. The event cannot take place tomorrow. Therefore, the event is unforeseeable and it was beyond the control of the parties. Therefore, the parties will be excused from performance of the mutual obligation. Sanam, are there any conditions precedent for the party invoking the force majeure clause?
Yes, there are. The party invoking the force majeure clause should be ready and willing to perform its obligation. And the force majeure event should be the sole factor restricting the party's performance of that obligation. For example, let's say that you ordered for a garment or makeup. The delivery should be to you on the 30th of March. Now, I am ready as the provider of the makeup and provider of the garments. I am ready and willing to perform my obligation. I have all the material in stock. However, I can't send out my delivery boys because I received the order on the 24th of March. And on the 25th of March, the government has restricted movement of all non-essential delivery people. Therefore, I am restricted from performing my obligation. However, the sole factor is the government lockdown, which is hindering my performance of my obligation. Which party can or should invoke the force majeure clause?
Like we already discussed, it is the affected party which has to invoke the force majeure clause. Now, in an EPC contract,
You mean it's the contractor, the affected party, who has to invoke it?
yes. Similarly, in a construction contract,
It's the party that was supposed to be constructing.
in a contract for delivery,
It's the person delivering, like we just stated, for makeup and for garments.
and in a contract for service.
It's the service provider that has to invoke force majeure.
What about in a lease agreement
It's the lessee.
and in a license for immovable property?
It's the licensor.
Just to go back to the construction contract, the purchaser, that is the home buyer or the shop buyer, the clause has to be invoked by the real estate company. So therefore, if they don't invoke it, later on they cannot take the guise of the force majeure clause in an agreement to say that we were prohibited from performing our obligation during these 3, 4, 5, or 6 months. So therefore, the home buyers must make a note of it. Now, Sanam, can financial difficulty allow invocation of the force majeure clause?
Absolutely not. Financial inability to perform the contract cannot excuse the party from performing its obligation. It simply doesn't fall under force majeure events. Changes in cost, unavailability of materials, components, resources, or services, or even changes in market conditions are specifically excluded from the definition of force majeure. Just because it becomes difficult financially for you to perform doesn't mean that you can invoke the force majeure event. Dheeraj, what steps should the affected party take to invoke the force majeure clause?
Well, just like everything else in life, communication is extremely important. Therefore, the affected party must notify the other party at the earliest possible opportunity of the force majeure event and how it is preventing the performance of the contract. Now, for example, there are certain contracts, especially construction, EPC, and other turnkey projects, which may have clauses which will require you to follow a certain procedure under the force majeure clause. Therefore, the parties are requested to read their documents and their contracts very, very carefully. Sanam, can we discuss an ideal situation wherein the contractor can invoke the force majeure clause?
Definitely, I can be the contractor, which means I am the affected party. I would have to immediately notify my principal, something like this. Dear sir, the movement of labor has been restricted owing to the declaration of lockdown by the government from the 25th of March to the 31st of May 2020. Therefore, I am invoking the force majeure clause.
If I am the principal, and an ideal principal in this case, I'd have to say, I'd reply something like this. Dear sir, your mail is well received. You are requested to resume work as soon as the lockdown is revoked by the government.
What are the consequences of invoking the force majeure clause?
Now, the consequences are threefold. Neither party is liable for failure to perform their contractual obligations, where that failure is caused by the force majeure event. Parties may be required to take steps to mitigate losses arising from the force majeure event. The performance of the obligation may be delayed until the force majeure event is over. The consequences listed here will depend on the wording and drafting of the contract. And foresee as many situations as you can, and the force majeure clause should be accordingly worded. Or if you take a case of a delivery, and if the contractor is to deliver the perishable goods to a hilly area, and the truck is prohibited from movement due to declaration of the lockdown, then the contractor may seek permission from the principal to sell off the perishable items during the goods, while the goods are in transit. Now, Sanam, does the force majeure event need to be specifically mentioned in the contract?
The answer is a clear and unequivocal yes. The force majeure event needs to be explicitly mentioned in the contract because it's a contractual provision. Therefore, whatever you have agreed upon will form a part of the contract and nothing else. So, if we take an example of COVID situation today, unless and until your force majeure event contains something like endemics, pandemics, or some government restriction, then yes, that event is covered under the force majeure clause. Dheeraj, what if there is no force majeure clause or the clause just doesn't mention the event? What then?
Well, then you cannot invoke the force majeure clause. No matter what, you just cannot. But do you think there's an alternate to it then?
Well, yes, there may be other options available to excuse non-performance of a commercial contract, such as the doctrine of frustration. It is much more restrictive in application than force majeure, though. It's governed by Section 56 of the Indian Contract Act. What is frustration of contract?
A contract is frustrated when performance by the parties is impossible, or when performance of the contract itself is impossible due to an unforeseen event. It allows the parties to cease performing contractual obligations where it becomes impossible to do so, when the circumstances are beyond the control of the parties.
So what I hear, Dheeraj, is a lot of impossible, which means that the threshold for frustration is higher than force majeure. Is that right?
Oh, it is absolutely correct. The threshold is much, much higher because you have to show an impossibility there. It cannot be that I am prohibited or my performance is hindered for the time being. You have to show that you just could not perform it.
For example, let's say that you have a ship that needs to reach a certain port by the 30th of April. Now, let's say that all the ports are closed, but the airports are not. So that contract doesn't become impossible. All I have to do is airlift the shipment instead of sending it by ship. So it doesn't become impossible to perform. It's just become more financially difficult to perform. Thank you so much, everyone, for staying with us for the second episode of The Brief. I hope you enjoyed it as much as we enjoyed bringing it to you. So stay tuned for the next brief. If you like this video, please click on the subscribe button below.
We'll be more than happy to answer your queries. You can just post them in the comment box.
I hope you guys enjoyed the brief and we'll be briefing you on multiple laws in the future.
Thank you so much for listening to us.